Hello guys, good afternoon. Happy Democracy Day to you. Thank you for joining this broadcast today. My name is KEVWE AKINDOLA, and of course this is Insights Radio, your number one online finance radio station. With me in the studio today is ETOMILADE on the show Business Law. You're welcome.
Good afternoon, listeners. Nigerians, happy Democracy Day. As she rightly introduced, ETOMILADE ODUOLA is the name. Okay. So I'm into estate planning and estate administration. Today,
ETOMILADE is going to be telling us a little bit about what estate planning is about. A lot of you don't know that there's more to estate planning than, when you hear estate planning, what comes to your mind is, real estate, buying property in Beduleki and all that. But there's actually more, and he's going to be expatiating on that for us today. So ETOMILADE, tell us, what is estate planning about?
Okay, before we talk about what estate planning is, I think it's important we talk about what is an estate.
Okay, what is an estate?
An estate is not your real property. An estate is everything you own. Okay. Your stocks, your bank account, your real estate, your cars, and other personal effects. They are part of your estate. Okay. So, the estate of an individual is anything capable of being owned by that individual.
Okay, anything capable of being owned. So your
anything
car is
you
your
can
estate.
take ownership of is part of your estate.
It's part of your estate. Okay, great. So at the end of the day, we now take it to estate planning. So estate planning now means...
Now talking about estate planning, because man by nature owns properties.
Okay.
Man and ownership are intertwined. Okay. So because of this, estate planning is how you can structure what you own in such a way that you enjoy it when you are there, and when you are no longer there, it passes to your beneficiaries with minimal crisis. Minimal crisis underlined because under the law, if there's any dispute as to anything under the law and you approach the court of law, the first thing that comes from the court of law is everybody maintain the status quo. So if everybody is to maintain the status quo, it means until that matter is resolved,
everything should remain the same.
Everything should remain the same. And in a case where the owner of an estate is no more, or probably is incapacitated, and the law says, or the order of the court says that everybody should maintain the status quo, it means that nobody will be able to take benefit, or even he himself
take a decision on
will not be able to take benefit of it. Wow. I will give a practical instance of what estate planning is all about, because everybody must ensure that they structure what they own.
Okay.
In the 60s, there was a minister in Nigeria. They used to call him flamboyant minister. I won't mention the name of the minister.
Yeah.
But when the minister was no more, his estate became an issue of litigation.
Wow.
And until 2014, it was sometimes in 2014 that the matter was referred back to the High Court to decide some things. So what's the implication for his estate? Let's consider that why they call him a flamboyant minister then was because he owned let's say 5 million in his account in the 60s. What is the value of 5 million today? So he has lost. Banks are feeding fat on whatever he owned then. And with respect to his real properties, tenants would have become owners
because nobody can do anything about anything,
because everybody is trying to claim ownership of it, and they are in court.
So court has said nobody should take any decision.
So
everything
remains. Said nobody should take any decision, and it's not about debt alone, because people always believe that when you talk about estate planning, you are talking about debt. It's also about the living.
Okay.
In an instance where somebody is supposed to take a decision in relation to his health and is unable to do so, the question is, who should make that decision? Have you structured your estate in such a way that you know who should make such a decision when you are unable to do so?
Wow.
So, because some people might be saying that, with this kind of sickness, you have to take him to Lagos Ibadan Express Road,
and somebody needs to sign.
And some other people will be saying, let's take him abroad. Some will be saying, no,
let's take him to one juju man under that bridge.
And there will be conflict as to there will be disagreement as to the kind of treatment he should be subjected to. Before you know it, the man,
will be conflict.
He has passed on, and the conflict still remains unresolved. So, in order to ensure that people get the kind of treatment they deserve when they need it, it's important that everybody structures his estate. I will give an instance in this regard.
Okay.
There was a client that walked up to us, and a very young man, he narrated the story that his dad, because he embraced another faith, the dad disowned him while in secondary school. So some clerics decided to take him elsewhere. He schooled there, they nurtured him, he got married. So years down the line, he decided to come around and even see his dad and see if maybe the dad
they can make peace.
They can reconcile. Unfortunately, he couldn't see his dad because the dad had 3 children, and 2 of the children were the begotten son of children of the dad. So when he came around, they told him that the begotten children had taken the dad abroad for treatment, for medical treatment. But abroad must have a name. But they didn't give any name as to what abroad. It was later somebody hinted that, oh, your dad was already locked up in one of the BQs in one of your gas stations.
Wow.
What happened to the man was that he was indisposed, and the brothers saw it as an opportunity
to take possession of
all his assets. So they pretended to the extended family, so that the extended family, in order to save themselves from the prying eyes of the extended family, they pretended that they were taking him abroad. So they took him to one of the gas stations. This was a man that suffered for his wealth. So they created a pigeonhole via which they passed through to him from time to time. And so they would go there, sign blank checks, and so the old man is still alive up to now. Unfortunately, he couldn't make decisions as to his estate any longer. In fact, it took our intervention and intervention of the court for him to be rescued from his begotten children. So let's take it that this man had a plan. It wouldn't have been this way. So this is the importance of estate planning. And it's not limited to that. It's also about generation next. Are you planning for the generation next? Are you planning for your children? Are you planning for their schooling? And what is the plan you have structured in place? There are so many vehicles you can use to plan your estate.
Wow. Because this thing just, like a light bulb just came up as you spoke. Because I remember sometime a family that I know, a close family to whose father became very ill. He had not died though, but he became so sick that everybody thought he would die. There's a kind of sickness that will just happen. This person is old, not in his 60s though, but he might not make it. And family people already came for papers of the house where the family, the children, and everybody is still living. So that's a clear case of no estate planning. Because if you give it to him, then they take it.
That's it.
But if you plan your estate and then something happens, how can they? So how do they? Is it that when something happens to the person, you guys, how will you people know and come in?
Planning is an A to Z thing, so it has a whole lot of processes.
Because what I wanted to say is the beneficiary going to know that this is something I am going to be doing when this person is not here? You will let the person know, or is it in obscurity?
Well, I think we will still get there. I think we should be talking about the tragedy of an unplanned
estate. Wow.
Because the law says that anybody that dies without a plan, then that person must have died intestate. That is, somebody that dies without a will has died intestate. So a man that dies intestate, the family will have to approach the probate registry or the court of law to obtain what we call letter of administration. That's why when somebody dies and then people want to access his bank account, they will tell them that go and get a letter of administration. And in getting letter of administration, the law says that at least minimum of 2 people, maximum of 4. And law also provides that, okay, these are the following people entitled to the estate of the deceased: the parent, the spouse, the children, the cousins, the uncles. They are all entitled. The nephews, the aunts, they are entitled. So many people are entitled, but maximum of 4. So the question is, how do you decide maximum of 4? I will give an instance. I won't mention the name of the estate. The man had 54 wives in this Lagos and more than 200 children. So tell me, how would they decide on 4 people to manage the estate?
Wow.
So, and once it's not managed, and I can count the number of properties the man used to own that have been sold, either by tenants, by somebody who took advantage of the documents and so on. And when this happens as a result of an unplanned estate, the children are left on the street. Legacy that should be perpetuated become decimated.
Wow.
And this is why it is important that everybody plans his estate. There was a couple that died some time ago in Port Harcourt. The couple worked in oil and gas, different companies, and they had 2 children. These 2 children were taken by the family to the village, and years down the line, the death benefit they got was in millions. The friends of this couple ensured, the friends of this deceased ensured that the family got the benefit. So years down the line, I think like 2 years thereafter, one of the friends went to the village and saw one of the children walking on the street. So by the time they tried, they did the investigation and so on, and the family was saying that there was no money. They had to use the money collected to do A, B, and C,
and left the children.
They were mentioned had property in Lagos, Abuja, and left the children. These children are citizens of the state, so ordinarily
they shouldn't even be. They can't even be.
So the friends came together and decided that can we just take
them,
these children, abroad? Do you know that the family still collected money from the friends before they could release the children? And that's why the Bible says something that the heart of man is desperately wicked.
It's really desperately wicked.
Not only that,
can you imagine?
Even the law says that even the devil does not know the mind of man.
So this one is deep. Even the devil doesn't know the mind of man. Estate planning is deep, guys. If you haven't, please, as like my head is opening up to a lot of things right now. Can you imagine that this is something that everybody should be doing?
It is important that everybody, immediately you start acquiring assets, you structure your estate. But there are instruments we use to structure. And briefly, we just go into it today to look at, what are the instruments you can use to structure one's estate. One is will. Wow. I know we don't usually want to hear about will, because when we talk about will, everybody thinks it's all about, once I write a will, I'm going to die. I have a client that is more than 90 years today.
And
his will that he has revised severally. His original will was older than me.
Wow, that's good.
So, and that's a man that plans about himself. Wow. So it's important that everybody does this. And in writing a will, it's not just about writing a will. Everybody believe that. Even lawyers make the mistake of believing that a will is a legal document. I do say that a will is not a legal document. A will is a legally binding document, because a will is written by the maker of the will, not by a lawyer. A lawyer is going to do the drafting and so on. However, the context, the expression must reflect the mindset of the testator. The testator is somebody that makes a will. So, and in writing a will must be expressed, because it's not a legal document. So all the legalists must be avoided in writing a will.
Let me understand that part. Because the will is not a legal document.
It's a legally binding document.
Because it is a legally
So lawyers shouldn't treat a will, when writing a will for clients, shouldn't treat it as one of the legal documents that they have to put all legalists in. They should remember that
it belongs
to the maker of the will. So it must reflect his expression, it must reflect his mindset, and the context must be what he intends, he desires with respect to his estate.
Wow.
So, and another thing about writing a will is that it must be detailed. In order to avoid contention, because one of the reasons why people run away from writing a will is because
people can say, I want to contest this will.
It's easily contestable in court. However, I do tell people that anything is contestable. If I feel that today, if I feel that June 12th should not be the democracy day, I can go to court. It's for the court to say that what I have that my presentation, my argument, or my point, or the reason why I've come to the court is not tenable. So it's the court that will decide that, whether I have a case or I do not have.
Wow.
So anything can be challenged. However, how you structure your estate will determine how successful such a challenge will be. For instance, if I write a will and I say that I give my wife this, anybody can come up in the future to say that she's the wife. So I have to
put her name.
Not only put her name, because it has happened in the time past that somebody mentioned a particular name in the will as wife, and when it was no longer there, 3 people came forward
with the name,
claiming the same name, and then they claimed that they were
that one
the person being referred to. So we say that go an extra mile, and in going an extra mile, say okay, so that I married on so day.
Oh, be detailed
at
about
so place.
Wow.
If there's a marriage certificate, no marriage certificate number is the same. So if there's a marriage certificate, you code the marriage certificate number in it.
What about the picture of the person himself?
If possible, you go an extra. You just must ensure that you go an extra mile. Define everything. If you use
as much as possible,
any word that appears controversial must be defined.
Must be, okay.
Fully defined that this is what
I mean. Wow.
Well, this is important in drafting a will. And then will, because will, you must know the extent of your property before drafting. Because planning is before you even go into preparing a will. There must be a schedule of your assets. What do you have? We shouldn't forget that we are talking about just an instrument. There are various instruments of planning an estate. So, 1, you must have a schedule of your assets.
Okay.
2, you must know the extent of your beneficiaries.
Okay, that's people who will get something.
People who will get something from you. You must be able to define them. Are they your children? Are they your wife? Do you have probably a concubine outside and so on that you intend to benefit from your estate? And another thing is about those who are going to execute your estate. That's another mistake, pitfall of in estate planning. Okay. We'll go into the details of this maybe in the coming period.
Okay. People who execute your estate. Wow. But I want to ask you a question.
Okay.
Now, you spoke about this whole estate planning thing. Does it have anything to do with age? Does it have anything to do with how old the person is? Is there a certain age to a person who can start estate planning?
Yes.
Let me give you an example. We have all these young artists. Now, let me take, for example, Wizkid. I don't know how old he is. I don't think he's up to 30. Is it okay for him to start estate planning now?
What the law provides is that before you can make a will, you must be at least 18 years old. That's in Lagos State and in some other states. But overall in Nigeria, once you are 21, you can plan your estate.
You can plan your estate.
So as long as you are acquiring asset, you need to plan what you own.
You need to start planning your estate, planning everything that belongs to you.
Yes.
Wow. That's good. Okay. So that being said, this extent of your beneficiary, now let me go there a little bit. Does it have to be what if the person doesn't have children?
Your beneficiaries don't need to be your children. It can be a charitable organization. It can be an entity. It can be a church, a mosque, or any other thing you decide who your beneficiaries are. But there are dependents. There are people who depend on you. If you are not going to provide for them in your plan in order to avoid crisis, so you must state why you are not going to provide for them. For instance, if you are going to disown or disinherit somebody, one of your children, you must be able to state why you are doing that. Maybe you have settled him in your lifetime. Maybe because he did this and you thought that
I don't want to give him anything.
Whatever he has done is sufficient for him. So on this basis you can decide, but you must state the reason, else it will be construed as an omission.
Because under the law, naturally you should give your children something when you're living, if you have.
The law provides for your dependents. You must provide for your dependents, those who depend on you.
That's your children.
Sometimes they might not be your children. They might your housemaid that you have been sending to school. And when you are no longer there, maybe you have a will, and the will does not address her education. She has a right of action. Because she's a dependent. going by the father. So you must be able to say that, okay, I've been sending her to school in the past years. However, I think I've done enough. Because the law might consider it as an omission on your part.
That you didn't put it there.
That you didn't put it there.
But somehow when we talk about this estate planning thing, it just makes me feel like it's for the rich people.
It's not for the rich people.
Because you know
do you know
take the occasion of your asset, that means maybe you have like 20 properties and all of that.
You don't need to have the whole world.
Okay.
As long as you have a bank account,
okay,
and you know that your supposed beneficiaries will not be able to access it. For instance, you have a bank account, you have even 100,000. Do you know how many 100,000, 50,000 are lying fallow in the bank that the beneficiaries cannot access it? Because they don't want to go through the rigors of obtaining letter of administration, or probably they even disagree among themselves as to who should obtain the letter of administration. Because the understanding in Nigeria is this: whoever obtains the letter of administration is the owner, and legally speaking, the executors of an estate or the administrators of an estate are the legal owners of the estate, but they are trustees of those assets to manage it for the beneficiaries. So they might be part of the beneficiaries, but it doesn't automatically mean that because they are administrators, they are the owners. Something happened in one of these oil and gas companies in recent past. A man was no more, and the next of kin came around. They gave the death benefit of the man, of the deceased, to the next of kin. And somebody obtained letter of administration later. So they claim that they have paid the next of kin. Next of kin is just a contact person under the law. It's not a beneficiary.
Wow, and the person had already taken.
So it became a matter of litigation.
So this thing is really...
So when you fill a form and you see next of kin, don't think you have planned anything. Next of kin is a contact person who should be contacted in case they need to get across to you and they couldn't reach you. So it's not automatically a beneficiary.
But what everybody has in mind is that when you say next of kin, you are the beneficiary. Even me, that's what I think.
No, it is not.
So next of kin is not beneficiary.
So you shouldn't be, my wife or my... some people will make
next of kin
a minor the next of kin.
Yes.
How would a minor be contacted in case of emergency?
Wow, so this is an eye-opener. So next of kin is not...
It's not known to
So
law.
even your next of kin should be somebody who can actually attend to
somebody that
mature
is accessible
enough and accessible. Not even just like mature to understand. Because even if you call a small baby, what can he do for you?
And
nothing
then it doesn't mean that the next of kin will take benefit of the estate. So it's either your executors take over your estate or the administrators of the estate take over the estate, but they will be administering the estate or distributing the estate to the beneficiaries.
But isn't that a mistake on the part of the bank?
It's not
because
a mistake.
Why did you issue to a next of kin when you know that it's not meant to be the next of kin that will take it?
No, it wasn't the bank that did this. It was the company that
just
that,
felt
okay,
that the
because
next
they had
of kin,
stated
this person as his next of kin.
KYC form probably with the company that, okay, next of kin, who is your next of kin? This.
Wow.
So the company felt that the next of kin was actually the same thing as beneficiary.
Okay. You know what? I want to ask a question.
Okay.
I want to create a scenario now. Now, I know of a family where there was a will. I want to believe that somehow this estate planning thing, you can also call it a will. Or a will is just a part of what it is.
It's an instrument of estate plan. We still have trust.
We still have, okay.
That's another entity entirely, another instrument entirely.
Okay,
we have medical or healthcare power of attorney.
Wow, so those are the types of estate.
Those are instruments to plan an estate. Estate planning is a single thing. So you can use it might be a combo of diverse instruments.
Okay.
It can be can be just a single instrument depending on the kind of structure and what you are trying to achieve. Okay. For instance, if you are trying to also minimize costs or estate duties and so on, because when a man dies and he has a will, the will be read at the probate registry. The law is that anybody that has a document that looks like a will should approach the probate registrar, who will look at it and then invite the stakeholders, and then the will be read. You know, a situation we have in Nigeria through our movies and so on, where a man will be no more, and then everybody will sit in the sitting room and they will be reading the will.
And they'll be reading the will.
That's meant for African magic.
my God.
His will is read
In the
at
court.
the probate registry.
Can you imagine?
So it's not
So
something.
you're not meant to be reading the will in the house.
No, that's for the purpose of movies.
That's for the purpose of. But it happens in real life, oh.
In real,
Me, I know somebody that died, and in fact, very recently, and they read the will in the house.
they will still have to take it to probate registry because the will. One thing is the will does not come into effect immediately it is read. The will would have stated who the executors, that is those who are going to carry out the instruction. The executors are those who are going to carry out the instruction of the deceased.
Okay.
So
And do they have to
before,
be the family
before they
people?
have the power, it depends on they
What
don't
the
need to
person-
they don't need to be members of the family. In fact, they must not be beneficiaries of the estate. Most of the time they can be, but it's sometimes advisable that they are independent entities.
So just like the friends that of that case you stated, where it was the friends who executed the will for them, and at the end of the day they had to come to look for the children because
Yes.
they are outside the situation now.
No,
So their mind
they
is
didn't execute. The friends didn't execute. The couple I talked about didn't have a plan. They didn't have a will.
They didn't do anything.
So they didn't do anything.
So their friends just came
So
together.
it was because they didn't do anything that the family was able to take charge of the
all
children
their,
and take charge of the assets. So if they had
had
had a
some
plan. If they had a plan, the plan would have stated, okay, how things should be distributed, who should get what, and then what should be preserved for the children, among others. So the role of the executor will be to distribute the estate, carry out the instruction of the deceased. But before doing that, they need a letter of authority from the court. That authority is what we call grant of probate.
Grant
of probate. So, but where there is no will, or the will does not name executor in the will, then you go for a letter of administration. So grant of probate, until they get grant of probate, the grant of probate is what they will now take to the banks and co, and then they become authority to deal with estate. So until a will, even where it is read either in the city room or wherever, they will still have to take it to the probate registry.
Okay.
And then they will have to commence the process of obtaining the grant of probate. And in obtaining grant of probate, the state is going to assess the entire asset of the deceased. And that is where an inventory form will be taken to banks and so on, where the bank will put in the form the amount in the balance in the account of the deceased. So the idea behind this is that at the end of the day, this will be assessed, and 10% of the value of the estate will be taken by the state as estate duty.
Oh.
So in UK, above a particular limit is 40%.
Okay.
So the idea behind estate duty is that the state has given you the enabling environment to acquire what you acquired in your lifetime. So when the man is no longer there,
you give back.
You give back to the state so that the state can empower others. Though that's in theory, but that's the theory behind it.
Theory behind it.
So 10% of the value of the estate goes back to the state.
Back to the state.
So another part of the pitfalls in people's estate planning is where you just have real properties.
You just have
real properties. The estate is not liquid.
Okay.
So if the estate is not liquid, where will you get money to pay the estate duty? So this will take us into a whole lot of other things like partial probate and so on. But we will discuss this in our subsequent episodes.
But before we go, I want to ask my own question, or maybe because our time is up, I should ask after the show.
Okay.
Okay.
Let me just round off by saying that a man that does not plan what he owns, that does not plan his life, we have to endure the one he gets. So it is important that everybody plans for himself. Planning is very critical.
Okay. A man that doesn't plan his life will manage what?
We have to endure the one he gets.
Endure what he gets. That is so true, 100%. So guys, you've heard it all from ETOMILADE. If you do not plan your life, you manage what you get. Estate planning is a big deal. You guys should start looking into it now. It doesn't have to do with your age. As long as you're acquiring assets, property, whatever, you should be thinking about planning your estate. We have this show every Wednesday at 2 p.m. right here on Insights Radio. So join us same time next week Wednesday as we do this again on Business Law. My name is KEVWE AKINDOLA, and I had ETOMILADE with me here in the studio. Till I come your way next week, have a great Wednesday.
Thank
Bye-bye.
you for having me.
Thank you.